Good afternoon. Nice to see some faces, familiar faces. I want to begin with a piece that was written by Liz Alden Wiley about just shy of a year ago, where she reviewed the national laws on community land rights for 100 countries. And she concluded that the legal recognition of collective land rights is, quote unquote, substantial and expanding. And so this is a great example of that. Her conclusion, based on her evaluation of these laws, were that 55 countries had 55 out of the 100 had strong laws protecting community land rights. And only 17 of those countries actually had no laws regarding collective rights. But we know that there is quite a bit of community land, indigenous and community land, that is threatened and insecure. We know quite a bit. We know that there's quite a bit of quite a few communities where custom is no longer sufficiently strong enough to protect the land rights of its members. We know that governments in many places are not providing the protections they need to guarantee those rights. And we know that increasingly communities that are under threat and know their rights are taking action even in the absence of government support. They're taking matters to court, they're mapping their lands, they are setting up patrols to monitor their lands. One activity that we wanted to focus on is a growing interest on the part of communities to register and to document their customary land rights, to bring it into the formal statutory system. And so we began a process of bringing together a number of researchers and a number of institutions. In fact, this has 9 authors, 6 organizations, and we began to look at the formalization process. And the way that we define formalization is that customary rights are registered in a government cadastre or a government register, and the government in turn hands out an official document regarding those rights that are recognized. We are very fortunate to have Ileana here, who is one of the authors, co-authors of the report, and she led the Peru effort. So if there's any questions about Peru, I'm going to pass them on over to Ileana to respond to. So I don't want to spend a lot of time on method, but I did want to give you just a brief overview of where we are with this thing. It was a 15-country effort. 3 of those countries we actually did deep field research in. The other countries we relied mainly on the literature. We examined 33 procedures. 19 of those were community formalization procedures. 14 of those were procedures that companies have to go through in order to get formal land rights. And in order to ensure comparability across procedures, across countries, and community versus company procedures, we identified 8 key issues. We developed a set of indicators for those. We scored those indicators, and if you want to see spreadsheets, we're happy to share them with you. So I don't have time to go over all of the results, but I did want to just go over and highlight some of the real key ones. This is actually the procedure in Peru, and those red boxes that you see are areas that are hiccups oftentimes. The procedure includes some very technical things, such as development of a soil map, which many communities obviously need quite a bit of help on. But Peru is not unique. In the Philippines, there are 56 legally required steps for indigenous people to get a certificate of ancestral domain. In Indonesia, 21 different government agencies need to be involved to get a title. In Uganda, it's a 17-step procedure that involves approval from some agencies at the local government, and in many districts, those agencies haven't even been established yet. As far as we can see, not a single community has a title of its land yet there. So there's lots of problems. The procedures are very complex and cumbersome, and in practice, they're actually even harder. There's lots of reasons why there is a slowdown in the formalization. Communities lack the resources, they lack the technical skills, they don't even have a deep understanding of the steps in the procedure. There's insufficient government support. In Cameroon, for example, it took a long time to create, to build the government institutions so they could actually provide the help that they should be providing. In many cases, communities rely on donors and on NGOs to provide that support to get that title. So when you count up the steps, on average, you can see that communities and companies are fairly similar in the number of steps. So these are the averages. But on the company side, many of those steps are associated with the licensing for the operation. And they're separate from the procedures to actually acquire the formal land rights. So you take those away, and it's very clear that, that community procedures have many more steps than company procedures. More importantly is, or just as important, there are a lot of companies that skip steps, that a lot of companies that begin their operations before they actually acquire the formal land rights. We know that those companies that are trying to do good, those that are trying to meet their responsibilities and meet the law, are actually at a competitive disadvantage to those companies that skirt the law and get around the legal requirements. So in terms of time, we see real significant differences. And I was actually, it was actually quite hard to get some good data on the amount of time. We had to get quite a range, but it is pretty clear that companies can acquire their formal land rights much quicker than communities. I should also say we didn't include the US, Canada, Australia, but if you look at those countries, and we did some literature review on it, it takes just as long for an indigenous group in the US or an indigenous group in Australia to acquire their land, and it's much more expensive, millions of dollars for a community to get recognized lands in Canada and Australia. So part of the reason companies do it this quick is they've got lots more resources to navigate the procedure. But just as important, I think, is that the company or the government agency that's responsible for helping companies with their investment are actually well endowed. They're very well supported. They have significant capacity, and they provide the support that's necessary for companies to get their lands. Part of the problem is that unlike companies, there is a steep burden on communities to address and resolve conflicts with third parties. That's not the case with companies so much, where as you can see, about half of the companies only required community consultation. Only 3 of those 14 procedures required consent from the community as IFPRI. This diagram here shows you the Mozambique example. But as I mentioned, I think those that skirt the law are at a competitive advantage to those who are trying to do the right thing. So just a couple of other slides. In practice, what we've seen also is that there are arbitrary limits of the amount of land that can be titled to communities. and many times there are gross errors in the boundaries that are drawn by the government. And many times you see different government agencies within the same country have different boundary maps of the same community. So there's a lot of challenges in that. But from maybe going back a little bit to what Ruth was saying, one of the things that was particularly problematic from my perspective is that our communities have to make huge sacrifices to get formal land rights, and those sacrifices come in a sacrifice of customary land and a sacrifice of traditional rights. And you know, when I think about this, is how serious must the threat be to their land for them to sacrifice some of their traditional land and some of their traditional rights? And let me give you just a couple of examples. In many countries, only the land that is used and occupied can be titled. Well, in many countries, the definition of used and occupied are the homesteads and the family farms, but not the commons that Ruth was talking about, the forests, the pastures, the wetlands. So they're sacrificing their commons in many instances. Just as important, they sacrifice rights within the part of the bundle of their rights. So, for example, they lose rights to pretty much all of the high-value natural resources on and below their land. And government is allowed to slap a concession on top of that and allocate those rights to a company to extract. Communities can use natural resources for subsistence and domestic purposes, but not for commercial purposes. So it locks them in to they can't compete essentially and take advantage of their opportunities. There are restrictions on management of their land, and there are oftentimes restrictions on the ability to exclude others. And in many cases, they can't sell and lease their land. So let me I've been told I'm out of time. We came up with a number of recommendations. Probably the most important is there needs to be a simple, accessible procedure for communities to acquire formal land rights. I'll leave this on the wall, but thank you very much.